Am I free to go?
I want my lawyer now.
I want a lawyer right now.
Mr. Nolan, it's for you. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. In Missouri, if you or someone you are trying to help is experiencing a medical emergency, neither you nor they can be arrested or charged with possession of a controlled substance, unlawful possession of drug paraphernalia, possession of an imitation controlled substance, keeping or maintaining a public nuisance, sale to a minor, misrepresentation of age by a minor to obtain liquor, purchase or possession by a minor, violating a restraining order, violating probation or parole. If you use drugs, ever met anyone who uses drugs, drinks alcohol, or has met anyone who does any other proceeding, you need to watch this video. There will be parts that are dry and boring. Look, it sucks, man, but that's the law. Tough it out and you may be able to save a life in more ways than one. The devil is in the details. So let's take a look at RSMO 195.205. Immunity from liability for seeking or obtaining medical assistance for a drug overdose. Paragraph 1. For the purposes of this section, the following terms shall mean. Now, when talking about the law, you have to understand what terms mean. Some words are not defined in the law, and we have to look to a dictionary and argue in court about the specific meaning of a word as used in that law. However, the legislature does frequently define specific words and statutes that they are meant to apply to. In this case, the phrases drug or alcohol overdose and medical assistance are defined. Drug or alcohol overdose is a condition including, but not limited to, extreme physical illness, decreased level of consciousness, respiratory depression, coma, mania, or death, which is a result of consumption or use of a controlled substance or alcohol, or a substance with which the controlled substance or alcohol was combined, or that a person would reasonably believe to be a drug or alcohol overdose that requires medical assistance. Now look at the terms used in the definition of drug or alcohol overdose. Extreme physical illness, decreased level of consciousness, respiratory depression, coma, mania, or death. These terms are not defined, but rather qualified with the phrase that a person would reasonably believe to be a drug or alcohol overdose that requires medical assistance. What is extreme physical illness? Is it vomiting? It could be. If you puke while passed out, you could die. Is it vertigo? It could be. I have a very fine sense of balance. Vertigo from illness or intoxication is the worst for me. Passing out or getting drowsy would seem to be a decreased level of consciousness, but how far is decreased? Is simply being tired enough, or do you need to start snoring? We don't know. What would a person reasonably believe? Now, we're not talking about the fictitious reasonable person, but rather what would the judge, the prosecutor, or the police officer reasonably believe? Look, respiratory depression? Hell, I don't even know what that means. And I doubt anybody else does either. How far depressed is depression? Does sleep apnea qualify? How about mania? I've represented people diagnosed with drug-induced psychosis. Mania existed, as did paranoia and some violent tendencies. Most people don't know what mania is, but police officers, prosecutors, judges, and criminal defense lawyers have seen it enough to be able to recognize it. And so the standard, what a person reasonably believes, is flawed. And I'm not going to talk about coma or death. You, a layperson, are never going to diagnose coma, and if you don't call 911 for a dead body, you got problems, man. The next term of art is medical assistance. Medical assistance includes, but is not limited to, reporting a drug or alcohol overdose or other medical emergency to law enforcement, the 911 system, poison control center, or a medical provider. Assisting someone so reporting, or providing care to someone who's experiencing a drug or alcohol overdose or other medical emergency while awaiting the arrival of medical assistance. Medical assistance is not actually medical assistance in this definition. It is reporting a drug or alcohol overdose or, and this is important, other medical emergency to law enforcement, a poison control center, or a medical provider assisting someone so reporting. So telling the RA that the freshman in room 104 is ODing meets this definition as long as assisting someone so reporting. After all the telling, now the definition protects the buddy who is providing care to the person who overdosed. This would be when you're sneaking back on the College of the Ozarks campus with your friend who just celebrated his 21st birthday and he pukes on your shoes while you're trying to talk your way past security. Under this law, neither the wasted friend nor the helper could be subject to criminal liability for the listed charges. Now, let's check out paragraph 2. A person who in good faith seeks or obtains medical assistance for someone who is experiencing a drug or alcohol overdose or other medical emergency, or a person experiencing a drug or alcohol overdose or other medical emergency who seeks medical assistance for himself or herself or is subject of a good faith request shall not be arrested, charged, prosecuted, convicted, or have his or her property subject to civil forfeiture, or be otherwise penalized for the following if the evidence for the arrest, charge, prosecution, conviction, seizure, or penalty was gained as a result of seeking or obtaining medical assistance. So now we've added good faith to reasonably believes. If you are seeking medical attention for yourself or someone else, or if you are the subject of a good faith request, the law says that person shall not be arrested, charged, prosecuted, convicted, or be otherwise penalized. Paragraph 3 of the statute, now that's the weasel section. There's always a weasel clause. So yeah, everything we said in paragraph 2 about not being otherwise penalized, well, all bets are off if you have the body of a varsity cheerleader in your trunk, or if you have a warrant. So let's check out paragraph 3. Section 1. This section shall not prohibit a police officer from arresting a person for an outstanding warrant under subsection 1 of section 221.510. Subsection 2. This section shall not prohibit a person from being arrested, charged, or prosecuted based on an offense other than an offense under subsection 2 of this section, whether the offense arises from the same circumstances as seeking of medical assistance. Now look, there's a lot of gray area here because of the crappy language used by the legislature. It doesn't say whether or not. So we have to grasp the legislative intent. Now frankly, I think the court is going to read an or not into the language, at least at the trial court level. But it could make an interesting appellate case. After all, the Oxford comma had to be settled in the Maine Supreme Court. Subsection 3. The protection of prosecution under this section for possession offenses shall not be grounds for suppression of evidence or dismissal in charges unrelated to this section. Look, this poses a really great appellate question because the clause in paragraph 2, which reads, quote, or is the subject of a good faith request shall not be arrested, charged, prosecuted, convicted, or have his or her property subject to civil forfeiture, or be otherwise penalized for the following if evidence for the arrest, charge, prosecution, conviction, seizure, or penalty was gained as a result of seeking or obtaining medical assistance, end quote. The reason this is interesting is that it conflicts with paragraph 3, subsections 2 and 3. Paragraph 2 says, shall not be arrested, charged, prosecuted, convicted, or have property subject to civil forfeiture, or be otherwise penalized for the following if evidence for the arrest was gained as a result of seeking or obtaining medical assistance. Note, there is no qualifier on the charges for arrested, charged, prosecuted, convicted. There is no comma after civil forfeiture, but there was after convicted. This tells us we have different lists. Arrested, charged, prosecuted, convicted, or if property subject to civil forfeiture is the list. However, the element or have property subject to civil forfeiture is directly modified with or be otherwise penalized for the following if the evidence for the arrest was gained as a result of seeking medical assistance. My read of this is that the clause, if the evidence for the arrest modifies only be otherwise penalized for the following, as there is not a closing comma for the list element. Additionally, it could be read to understand that the following only applies to the be otherwise penalized clause as indifferent from arrest, charge, prosecuted, and convicted. That read would shred this weasel clause. Of course, that speculation is what an appellate court in the Missouri Supreme Court might do if the question was properly framed and before them. The important thing to take away from this statute is that we as a society want people to seek medical attention if they or someone they know is experiencing an overdose. We are willing to waive prosecution for small-time offenses in exchange for saving lives. If you like what we're producing, please hit like and subscribe throw in a comment in the comment section. We have posted our medical marijuana lease addendum packet as a free bonus for our Patreons. Consider becoming a Patreon and gaining access to those benefits as well. That's patreon.com/PatTalksLaw. Thank you for watching. We'll be seeing you soon.